Welcome back everybody to the criminal law. In this video we're going to take an introduction to sexual offences, the next major topic in our series of lessons focusing on specific criminal offences. Now, sexual offences are very unique in a number of different ways, especially in terms of procedure, in terms of theory, and in terms of evidence. And we're going to try and touch on these in those kinds of details in this series of lessons, while also maintaining the fact that this is merely a series on the criminal law, and this is not a series on criminal evidence or even a series on criminal theory, which could be in the future lessons that we do. But for now, we're talking just about the criminal law. And like I said, we're moving away from the subject of homicide, which included murder and the various different kinds of manslaughter offences, and an examination of sexual offences. We'll spend some time in this lesson introducing and examining some of the theoretical implications when it comes to sexual offences, as well as talking about the development of the modern law on sexual offences, the implication that was had in relation to the imposition of statute into sexual offences with the passing of the Sexual Offences Act from 2003. Speaking of which, let's begin with that. Law reform is always a very interesting area that we have to always focus on and keep in the back of our mind, because the Law Commission and the International Law Commission, depending on what jurisdiction we're talking about, is always constantly thinking about new and better ways in which we can model and design the law to serve the people in ways that it should do. And sexual offences has always been an area that has a lot of difficulties, partly because of the very, very low conviction rate in comparison to the allegations of offences that have been committed. And this also plays into the fact that the evidential burden for sexual offences is particularly difficult in a lot of circumstances, and also the societal perception of sexual offences are very difficult. As a result of which, it is not uncontroversial to say that sexual offences forms something of a unique bubble of criminal offences that are set apart from other types of offences like dishonesty offences or maybe non-fatal offences. They are unique in their conduct, in how they're committed, and in terms of how the criminal law deals with them. And so the Sexual Offences Act of 2003 represents a very considerable reform to the legal system, specifically around, as you can imagine, sexual offences and the criminal law. Now, there were a number of motivations for the reform to be in the form of sexual offences. So, of course, there are academics, and there are lawyers, and there are judges, and there are solicitors and barristers who are always consistently critiquing elements of the law as they stand. And the Law Commission is, of course, tasked with the process of trying to make recommendations for reform, and they have to make decisions for what to actually recommend for reform and for what Parliament to eventually pick up on and actually take forward for reform. And it was considered in 2003, or at least before 2003, that sexual offences ought to receive some major and substantive reforms. In the 1990s, there was this public perception of sexual offences, more so than other common law offences in England and Wales. So there was a general societal impetus towards recognition of sexual offences, and this ties into the fact that because of this growing public perception of sexual offences, there's a growing critique of the law in its ability to deal with sexual offences, at least when it comes to the original pre-2003 common law method for prosecution of sexual offences. The public perception had a number of consequences. It showed quite substantially and quite clearly that the law was outdated as late as the 1990s. And it was also a considerable lack of convictions for sexual offences versus complainants. This is something that continues to be a problem within the criminal law more broadly. Sexual offences, in terms of allegations of sexual offences, are very, very high compared to their number of successful prosecutions, the successful convictions of sexual offences. There are a number of reasons why this is the case, and it's not really for this lesson to try and dive into the root cause of this particular problem. because it probably is an intersection of problems. There are problems in relation to the growing perception of sexual offences in society. That is on the part of the persecutor, the person who is doing the sexual offences. But there is also a growing understanding, or at least a or growth of ideas relating to the ways in which the complainants feel they would be perceived when they make complaints about sexual offences. Okay, often there are complaints that are made that alleged victims don't feel heard in certain circumstances when they make allegations of sexual offences. There is often a quite substantial time element between the committing of the offence and the reporting of the offence, meaning that any kind of evidence of the offence is unlikely to be around anymore. All of these are huge problems when it comes to trying to essentially prove an individual guilty of an offence, because one of the things that sits at the heart of all of this still is the presumption of innocence. And so sexual offences really do have this unique ability, or at least this unique inability, to actually be successful in a lot of instances. So we also see, finally, as well, in terms of the impetus to major law reform, a policy prescription made by the Home Office. Now, as I've mentioned already, and as I've sort of alluded to earlier on in this video, that sexual offences has attached to it a number of unique procedural as well as theoretical implications, despite the fact that men can also be the victim of sexual offences. For the most part, sexual offences are gendered crimes. This is an interesting element. A lot of violent crimes can actually be considered to be gendered crimes in a way. A lot of, but sexual offences is incredibly skewed in terms of the gendered elements relating to it. It gives rise to a distinct lack in shared societal understanding. Okay, so the sort of epistemic foundations from which we understand criminal offences is not shared consistently across all of society, given the fact that for the most part, when it comes to sexual offences, men are perpetrators and women are victims, and it is not really the other way around. For the most part, when it also comes to sexual offences, the majority of perpetrators are men and the majority of victims are women, as I've just mentioned, which again gives a unique element to it. And that's why when we talk about criminal theory, there are lots of different critiques of sexual offences legislation and sexual offences law in lots of different areas of theoretical literature. So things like feminist theory have quite significant critiques of sexual offences litigation. In addition to this, and also from a theoretical perspective, sexual offences are perceived as violent acts. Now, crimes such as rape are described and perceived as violent acts. There is also deeper implications to be had there. They are not just mere assaults or mere ABH cases, or they are, in reality, crimes which include fear and humiliation, as well as the objectification of human beings. So there is a far deeper psychological element relating to sexual offences that is not necessarily recognised in other kinds of non-fatal attacks that are done. That is not to suggest, therefore, that if you are assaulted or somebody has committed ABH or GBH against you, you don't suffer or can't suffer any kind of psychological harm as a result of that. Many people do, but crimes such as rape and sexual assault carry with it this significant psychological element as well. One of the reasons for this is the grounding of offences like rape in the general view of personal autonomy and the deprivation of choice and control. One of the things that sits at the heart of sexual offences is this view and this idea of consent. And consent essentially pertains to the victim or the complainant's ability to choose to or to not engage in sexual activity. And having that choice forced upon you against your will is something that is very deeply enshrined within sexual offences law. Now, even when rape is accompanied by further acts, the objectification of a person is dehumanizing, and the result of which is a denial of their personhood. So you can really get into the weeds relating to the theoretical implications and the harm that is done as a result of sexual offences, which gives us an indication as to why they are considered so serious in terms of the criminal law, why many sexual offences have conditioned on them life sentences, which we will get to in a second. So given this theoretical background and this theoretical understanding, I've barely scratched the surface of the theory, because this is not a theory lesson. We're talking about the law in terms of its substance and in terms of its procedure. The Sexual Offences Act of 2003. Now, the following offences are found in sections 1 to section 4 of the 2003 Sexual Offences Act. In each of the cases, it is up to the prosecution to prove that the victim did not consent to the activity that is being cited, and that the defendant did not reasonably believe that the victim had consented. So you have two elements that we have here. Not only do we have to show that there is a lack of consent in the case of the complainant making that making the allegation heard, but it has to be a little bit more than that. Not only do you have to show that there is a lack of consent, but also that there is a lack of reasonable belief in consent on the part of the defendant. Section 1 outlines the crime of rape. Section 2 is assault by penetration. We'll get to the distinction and the difference between these two in future lessons, did I say. Section 3 is sexual assault, and Section 4 is causing a person to engage in sexual activity without consent. Okay. When we get on to looking at sexual offences against children, these relate to sections, I believe, 5 to 9 or 5 to 8, and they broadly mirror sections 1 to 4, but in relation to people who are under a certain age, depending on the kind of offence we're talking about, either under the age of 13 or under the age of 16. We'll get to all of this in future lessons' time. In the previous lesson, we took an introduction to sexual offences, the next of our major substantive set of criminal offences that we are going to be exploring. This lesson is going to focus specifically on the legislation that is in place now as a result of the law reform that took place between sort of the early 2000s up to 2003, and then focus on the first of the major offences, which is, of course, the crime of rape. So the crime of rape is outlined namely in Section 1 of the Sexual Offences Act. You have Section 1 to 4, which looks at the various different sexual offences relating to adult activity, and then the provisions after that sort of mirror the sections of 1 to 4, but in relation to children. So Section 1 is rape, Section 2 is assault by penetration, Section 3 is sexual assault, and then Section 4 is causing an individual to engage in sexual activity. Let's begin with the first one. And really, the good thing about this set of lessons and these provisions is that it is statutory. And the result of that means that you can simply read down the statutes, you can pick out the actus reus and the mens rea, and then you can look at some of the case law which looks to establish and to essentially outline some of the more nuanced elements of these particular acts and these particular crimes. This is good. This is unlike a number of common law offences, so things like assault and battery or things like murder, which are a little bit more complicated. You have to examine some more case law instead. The Sexual Offences Act is very, very neatly defined and defines these sexual offences in quite a nice, simple way. And so rape is defined in Section 1 of the Sexual Offences Act, and it is defined as follows. It says that a person A commits an offence if he intentionally penetrates the vagina, anus, or mouth of another person B with his penis. B does not consent to the penetration, and then finally A does not reasonably believe that B consents. Whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps the defendant A has taken to ascertain whether or not B consents. So we're talking about the reasonable belief in consent and the various contexts and contextual elements which have to be outlined and defined when we think about how we determine whether or not A believes reasonably in the consent of B. Subsection 3 says that Sections 75 and 76 apply to an offence under this section. We will get to that in future lessons and a little bit at the end of this lesson as well. Subsection 4 says that a person guilty of an offence under this section is liable on conviction on indictment to imprisonment for life. So this is just the procedural element of the offence. We're talking about if you are found guilty of the Section 1 offence, if you're found guilty of rape, you are liable on conviction on indictment to imprisonment for life. You get a life sentence as a result. Let's pick out the various different criminal elements of this offence. Let's begin with the actus reus. And we're just going to go back over this provision again, but it's going to be highlighted in red, the actus reus elements of the offence. So if we just have this out here like so, we can see that section 1, subsection 1a and b outline the actus reus, the acts that have to be committed. So there is the intentional penetration of the vagina, anus, or mouth of another person with his penis, and then there is also the fact that the victim, B, does not consent to the penetration. Now, this is going to be quite interesting and something that we're going to touch on a little bit more as we go on. The victim's state of mind here is part of the actus reus. It is part of the act itself, and this is quite interesting to note. Okay. In addition to this, the mens rea is as follows. We have the intentional penetration, so there is an intent that is required there. You intentionally penetrate the vagina, anus, or mouth of another person. So some of the mens rea is tied up in that particular provision. But then there is also part C of subsection 1.1, which is, of course, the reasonable belief in consent. Okay. So you have to have a number of different elements. You have to actually do the act itself, which is the penetration. You have to intend to penetrate another individual in these particular ways. And you have to not believe in the consent of the victim, and the victim also has to not consent as well. So there has to be not only a lack of consent in and of itself, but a lack of belief as to consent in and of itself. So those are the actus reus and mens rea elements of the offence. Going back to the actus reus, the Sexual Offences Act introduces a certain degree of gender neutrality for the victim of the offence. So despite the fact that in previous lesson we looked at taking an introduction to sexual offences, and we noted that one of the things that's very interesting about sexual offences is the idea that they are often very gendered offences. They are often the victim are often women, and the perpetrators, the defendants, are often men. Despite that being the case, the legislation does not include this kind of gendered representation, shall we say, for the victim of an offence. Okay, they are gender neutral. You can be a man or a woman and be a victim of rape under Section 1. And it also allows the idea of trans defendants, since this does not define the perpetrator as a man, but just as an individual with a penis. And of course, trans women can also have penises. So the result of this is that there is a certain amount of gender neutrality in the crime of rape. But the limitation to this is the fact that the perpetrator has to have a penis, because rape is done with this individual's penis. And there needn't be a biological penis either. It could be surgically constructed. But what this is essentially telling us here is that the only thing that is a requirement for a defendant to be charged and ultimately prosecuted with a Section 1 offence is having a penis. Now, this does raise questions about the need for maybe potential further law reform, because the clear distinction between rape and assault by penetration is not necessarily easy to define. And we'll get to that in the next lesson as well, and we'll get to what some of this means and why this is so interesting to discuss, and why there is still further reform potentially left to go in this area. The actus reus is also satisfied with the state of mind of the victim. So you have to do an act, but there has to also be a lack of consent from the victim in the doing of the act, which is why we have actus reus forming part of the state of mind of the victim as well. Now, penetration in section 1 is defined in section 79 subsection 2 of the Sexual Offences Act as, quote, a continuing act from entry to withdrawal. Given the fact that the idea of penetration may not necessarily just involve one particular instance of penetration, it could be a continuing period of time. You have a continuity here in terms of what actually constitutes penetration, and this helps for the allowance of coincidence between actus reus and mens rea, because there could have been situations where an individual, for example, did reasonably believe in consent, or maybe didn't reasonably believe in consent and then did reasonably believe in consent, and there's a sort of situation where you don't have a coincidence of actus reus and mens rea, and therefore you could escape liability. What section 79.2 does is tell us that essentially penetration, the act itself, in which penetration is a component and vital element of, is a continuing act. So the actus reus and the mens rea can coincide with each other.